included in your listing contract.
Oh, absolutely, must be. Yeah. The real estate board, you know, they won't put it up if it's not there. It's got to be in your contract when you turn it into the board. And therefore, so, you know, so, I mean, people argue, does the seller realize what that means, you know, blah, blah, blah. I don't know. You know, I'm certainly hoping so, but I don't know.
But it shows up in the comments, in the private comments.
Yeah, and that's
it doesn't show up in the compensation spot.
There'll be a asterisk there.
Oh.
And then it's in Realtors comments. There's not enough room in that field.
Oh.
If it ever comes a point in time when there's enough room, then it'll all go in there.
Okay.
But you can't get it all in there, so you put an asterisk in there, and you look in the Realtor comment, and you'll see the full thing spelled out. Yeah. Okay, any comments? What else? Other than scheduling. Natalie's been trying to get me to talk about the do not solicit. Okay, the real estate board has a program and has had for some time now that if a client, like a seller of some sort, usually does not want to be solicited when their listing expires, we have given the seller, not the realtor, we've given the seller, so they won't be annoyed with our profession, the ability to let us know that they do not want to be solicited. So the seller must write the letter to the board, and the board will put it on. Okay? I think it's unfortunate. I'm trying to get the rule changed to make it clear, but some realtors are slipping it into Schedule A without ever going over it as to what it means. And therefore automatically causing us an environment where their listings, when they expire, will never be solicited. That's totally unfair, in my opinion. It needs to be the seller, and in my personal opinion, it needs to be in a separate written document or form or letter, separate from the listing agreement. So they absolutely sign and approve that. Okay, then it's put on there. Now, the big question that comes up is, when does it expire? I don't know. I'm making up my own rule. My own rule is, you know, it's hard when you come down to rules to cover everything. It really, really is. Like this, and the more fine-tuning you put into rules and regulations, the more creative people get about how to get around it, right? It's better off leaving it broad sometimes and just saying you can't do it, right? But what I want to see happen is that is separated completely, and what I believe is that when that listing is now relisted or sold in the future, it's gone with that listing, if you know what I mean. So if the last listing listed expires and they have do not solicit on there, or don't contact this person on there, then that would stay alive as long as that property is not relisted or sold again, for as long as that goes on. Okay, that's why it's put on the listing. We used to have a list, I think we might still have it, but I'm not sure about that, but we used to have this list of all the properties. Well, the problem with that is it stayed there forever and people never knew. It could be 10 years later and it's sold 3 times and I still can't solicit this property. Like, it wasn't meant for that. It was for that particular client. So if that client then goes back in a year's time or 2 years' time, puts their house back on the market with another realtor or sells it, and another buyer, another seller moves in and then relists their property in the future, it's gone, in my opinion. It was stuck to that one listing. Well, that's the way I'm looking at it. Yes?
Does that have to come in at the time you take the listing, or can it come in just before it expires?
It can come in any time. I had one poor lady wrote me late last week, absolutely beside herself, because she had a cancellation with a 90-day clause on it, and she thought that prevented her from being solicited. And I told her, I said, listen, she's an elderly lady, and I said, listen, that does not protect you from that. You know, so what I'm going to do based on your letter is have the MLS add that, because that, you know, that's obviously what you want. And you've written this letter to me, so that's what we'll do. So it can be added at any time. Okay? And there was one other one on my list. Oh, all measurements of prox. What was that? No, just that comment. I'll say this: like we do run into listings, all measurements of prox quite often. I want to make it very clear that the Code of Ethics and Standards of Practice make it very clear that as a buyer's agent, that does not let you off the hook. You are responsible, if it's a concern to your client, to check out anything in that listing, including measurements. But it also does not let the listing agent off the hook either. So you both have responsibilities. And if something, whether it's measurements or whether it's right-of-ways or easements or power lines or future construction or whatever the issue may be, if that's of concern to your client, your buyer, then you need to not just listen to the listing agent, you need to do your own checking out, because that's your client, that's who you work for, and you're responsible to them. Okay, so the homework needs to be done by the buyer's agent as well. So just because they put, the proxy thing is probably a good sort of heads up, if you like, to check this a little closer if it's of concern to your buyer. I mean, if it's not of concern, that's fine. If they're aware of it, that these are approximate, that's fine. But if the buyer is saying to you, I want to put a pool in my backyard, then you better go out of your way as the buyer's agent to make sure. Don't just listen to the listing agent, to make sure that that is doable. Okay, that's what I have.
And if you're selling a foreclosure strata, you are responsible to get all the documents, not the listing agent.
Well, that's
Apparently.
interesting.
That's what happened
So-
to Roslyn.
So a foreclosure strata, the buyer's agent is responsible?
For the
Yeah.
information. Because they're not responsible for its buyer as is, where is.
That is when they add the clause, if they send you the sheet that has all the
Yeah.
of omissions, and
Yeah.
they just waive
Yeah.
everything, and you just write in there, it says you buyer will get stuff.
But I'm not so sure, and I'll check that one out. I'm
Okay.
not so sure, though, that the listing agent doesn't legally have an obligation to produce that information. Because you see the requirement, now, let me back up. I was reading something recently, I don't know where it was, the council maybe? I think it's in the council, in the current council newsletter, that the only form that's absolutely required by law is the Form B. Interesting enough. And we've expanded that over the years to include all the minutes, all the, all the stuff, and we write that. And that's why it's really important for you to write everything into your contract that you want. If it's studies, property, strata studies, whatever it may be, make sure you write it all in. Because I didn't realize before, but from council's view, the only legal obligation is actually the Form B. And I didn't realize that. So, because we've automatically assumed it had to be all documentation, right, is required by law. But I'm still not sure the listing agent doesn't have that obligation, even if it is foreclosure. And I know they waive it. That's because the seller, who's the court, probably, or at least, or the bank, they don't have any way of guaranteeing it.
It's the trustee that's
Yeah,
handling it.
that's fine.
The one that forces you to take on that
Yep.
sheet of paper.
But I still think the listing agent has a duty. And I'll have to verify that one. Get back to you.
Okay.
Is that it?
Yeah.
All right, thank you very much.